Good morning, everybody. It's Dave Neal here, stand-up comic, host of the Rush Hour podcast, with an update in the Blake Lively versus Justin Baldoni court case. We have a response by Jed Wallace. He is the dark lord that Blake Lively alleges is head of the conspiracy theory from Justin Baldoni's team. They hired him, so she says, to sort of smear Blake Lively. His arguments are like, we didn't have to do that. Nobody liked you. You know, they hired me to take a look at you. We realized, hey, we don't even need to. It's almost like hiring an arson to start a fire, but then you show up and realize the whole town's ablaze, and you're like, I think we're good. You don't need my matches. That's at least the argument he's going to make. A lot of conspiracy theories floating around here. I'm just going to read all of his introduction, and we'll kind of jump through the legal kind of BS that we don't need to kind of cover here. Because a lot of this is about jurisdiction. You know, is it in Texas or New York or LA? And really, his side responding, Jed Wallace's side, saying, hey, I don't think, you don't even need us here. And now, of course, my response is, bring everybody. I want everyone there on the baseball field. I want Judge Lehman, in an umpire uniform, calling balls and strikes on this. It's so complicated. But that's just me. That's just, who cares what I want? I mean, I don't think they're taking me into account. Maybe, I don't know. Jed Wallace, are you a fan? Either way, here's his introduction. New documents. And I was going to try to push this back because we're so slammed, but we have more documents coming out tonight and tomorrow. So we're just trying to fit it all in. I hope you guys appreciate it. Hit the like button and subscribe. And by the way, today's afternoon rush, we've got theories from PR professionals that Blake Lively is floating a settlement. That's coming next. Subscribe for that. It's coming, I promise. Lively's response does not attempt to show personal jurisdiction over Wallace or Street under New York's long-arm statute, but rather her theory of personal jurisdiction, a conspiracy-based theory. So they get into the sort of if it's a conspiracy theory, it doesn't matter where you live because the acts were done in different places. This still developing but chaotic theory has already created an active and jagged circuit split. The Supreme Court has never weighed in on conspiracy jurisdiction as a form of personal jurisdiction over civil defendants. And then they cite some case law there. Nonetheless, the conspiracy theory has been accepted in the Second Circuit, but under circumstances far removed, indistinguishable from those here. For example, the only substantive case plaintiff cites in support of her conspiracy jurisdiction theory, Charles Schwab Corp. Versus Bank of America Corp., noted that defendants do not contest Schwab's statutory basis for personal jurisdiction under California state law, contrasted here with the Wallace party's vigorous and unrebutted argument that the New York long-arm statute does not reach them. Here, Lively's only allegations regarding conspiracy jurisdiction are made on information and belief, argumentative inferences, and legal conclusions couched as factual allegations, which this court need not credit. And even those allegations, however characterized, must be taken as true, only to the extent they are uncontroverted by the defendant's affidavits, whereas here, jurisdictional discovery has not been conducted. Lively claims, wrongly under settled and binding authority, that this court should ignore the Wallace Declaration. But even if the court does not credit the Wallace affidavit, although it must, plaintiff bears the burden of establishing conspiracy jurisdiction and yet does not allege when or where the conspiracy was formed, who was in it, at what point in time, what acts the alleged co-conspirators, none of whom are New York residents, performed in New York, with one irrelevant exception discussed below. How the conspiracy was aimed at or directed at New York, especially when the complaint does not allege any territorial boundaries for the sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone, not just New Yorkers, that challenged his Baldoni's brand. Where the Wallace parties joined the alleged conspiracy, apparently it was later, and what they specifically did to further the aims of the conspiracy in New York, and Wallace's awareness of those acts taken by the alleged co-conspirators, and that those acts were in New York. So kind of what they're saying is, where's the smoking gun? You don't even know where or when the conspiracy took place because it's untraceable. Can't get more tinfoil hat than that. For venue, Lively totally ignores that the plaintiff bears the burden of showing that venue is proper for each claim against each defendant. So then they get into this venue thing. I don't find the venue thing that interesting. I mean, maybe for them it is because they don't want to have to be in New York for a month for a trial, if it goes to trial. Finally, if the court reaches the merits, it should dismiss. To avoid a hustler, Lively argues that Wallace and Street did far more than publish statements, but her complaint says otherwise. In her own California cases, support dismissal. For false light, either New York law or Texas law applied because Wallace's alleged conduct occurred in Texas, and the purported ultimate impact was felt by Lively in New York. Lively cites the amended complaint do not add up to knowledge her California cases go against her, and she ignores that Wallace was not her employer. So then they get into personal jurisdiction, and they get into, whether, this is where this text messages come in where she claims that they were there to destroy her. Wallace merely observed social media passively. And this is what he claims in his sworn affidavit, and recommended that everyone should let the sentiment on social media unfold organically and not to do anything. So were there a conspiracy to destroy Miss Lively and punish her, Wallace and Street were not an integral part, nor does the complaint allege as much, although the response belatedly claims the Wallace parties at some point in time became an integral part of the conspiracy. Much like the complaint, response ignores that there's a three-pronged test serves a purposeful available requirement rather than supplements. Oh, sorry, that's citing Schwab. It does not dispatch with the principle that a defendant should reasonably anticipate being hailed into court in the forum. So to confer jurisdiction, defendants must have known of or should have anticipated overt acts in New York to advance the conspiracy. So that's what they're sort of arguing here is where's the big advancement? Where's the blueprint of this conspiracy? In advocating for personal jurisdiction, Lively never identifies any specific co-conspirator committing any specific act that qualifies. An act taken while physically present in New York that she is seeking to impute to Wallace through the conspiracy theory jurisdiction. In fact, she never once cites New York's long-arm statute. Just like conspiracy theory jurisdiction is not a substitute for purposeful availment, conspiracy jurisdiction is not a substitute for application of the long-arm statute, but a series of the agency theory to meeting. So yeah, I don't know what a judge is going to rule here. At most, Lively points to AC paragraph 26, which characterizes Sorowitz's comments that he would spend $100 million to ruin the lives of Miss Lively and her family, which later really turned out to be a statement that he was prepared to spend whatever necessary to defend Baldoni, Wayfarer Studios, and himself. But Lively never explains why this comment is tortious conduct in New York, or that Wallace was aware of it, let alone both. No other paragraph that Lively points to in the response for personal jurisdiction mentions New York, nor does any paragraph allege any awareness in general or of any specific act in New York. Boy, nobody wants to go to New York. I'll go to New York. Let's go to New York. I'll be there in June for stand-up comedy shows. Follow me on Instagram. For Wallace's participation in the conspiracy, Lively cites two paragraphs to support that tag, and of course, whenever we have tag, we have a tag button. Engaged Mr. Wallace in street relations to design and implement a social combat plan. The first paragraph are text messages between Abel and Nathan that never mention Wallace or Street. The next paragraph is an allegation on information and belief, tag. Engaged Mr. Jed Wallace around the same time in early August 2024 to design and implement their social combat plan. First, this is exactly the type of conclusory allegation based only on information and belief that are not sufficient to provide factual support. Second, this court generally takes the allegations in the complaint as true, but only to the extent they are uncontroverted by the defendant's affidavits. Lively instead claims Wallace's declarations is irrelevant to the personal jurisdiction analysis by misciting the Dorchester, okay, so then it gets into this case law here. So this court can look to Wallace's declaration and see Lively did in fact lack the specifics of the conduct by Mr. Wallace because her general allegations get his conduct all wrong. Wallace or Street did not post anything on social media on behalf of the Wayfair parties or about Lively or Reynolds or any of Lively's or Reynolds' businesses. They didn't direct or ask anyone to post anything about the same. They didn't publish directly or indirectly any information or content, negative or otherwise, regarding Lively. And Wallace specifically forswears that a social combat or social manipulation plan is not a service he provided related to anything in this case. Third, even setting aside Wallace's declaration, paragraph 216 is merely an allegation that tag hired Wallace to design and implement, not that Wallace actually did design or implement anything. Paragraph 215 and 216 do not plausibly allege what overt act Wallace actually ended up taking, namely what Wallace designed or did to implement any so-called plan. Lively wants this court to draw an inference from her conclusory information and belief that Wallace was hired to do an amorphous retaliatory campaign and that he then carried it out. but she never gets into specifics. Even if credited by the trier, this allegation would not suffice to establish jurisdiction over the defendant. Beyond those two paragraphs, Lively generally gestures to her background sections, page 6 to 8. The allegations on page 6 describe Wallace and Street relations, but do not allege that Wallace did anything here. On page 7, Lively finally gets to what she supposes Wallace did, seeding, manipulating, and advancing disparaging content on social media platforms and internet chat forums. But this is just another way of saying Wallace and Street retaliated against her, a threadbare recital of her claim and a legal conclusion couched as a factual allegation. As for paragraph 250 to 57, these are more vague references to a digital team, not Wallace or Street, especially that Lively says Nathan and Abel merely discussed working with Wallace. She also bolds and italicizes other vagaries, like efforts to shift the narrative from some random tag employee who is not alleged to be part of the conspiracy. But bolding and italicizing her conclusory claims do not make them any more specific in the face of Wallace's declaration explaining specifically that he did not post, like, boost, or ask anyone else to do so. Whatever Lively says about Nathan and Abel, what she does not say is that Wallace made any particular post, liked, or otherwise boosted any story or post, or really explain how Wallace joined in on the alleged conspiracy to destroy her. That is because if it happened, which Wallace cannot deny it did because he was not there, but again he doubts, Wallace did not involve Wallace. As Wallace explained in detail, his recommendation was to do nothing on social media because Baldoni was already organically crushing it on Reddit. This paragraph, however, admittedly corroborates one allegation in Lively's complaint, where Lively posted a chart showing online sentiment began to turn negatively in July, 2 weeks before Lively alleges Wallace was hired. Lively's complaint stays at a high level because she lacks the specific, but now that she has them in Wallace's declaration, she wants the court to disregard them. It remains true that this court has recognized it remains true that where a plaintiff advances only conclusory allegations to contradict defendant's specific avertments or evidence for refuting jurisdiction, such allegations will not suffice to create the necessary prima facie showing that the court may exercise personal jurisdiction. So what he's saying is, they didn't have the info. I gave them the info. Now they want me to dismiss that info, even though that info shows he had nothing to do with this. Lively is not entitled to jurisdictional discovery. So then they get into that part. They get into the venue, which I don't think we need to talk about. And I think that's really the juice of it. Lively's actual malice allegations amount to one paragraph that she has a threadbare recital of the element of actual malice. So this is getting into the defamatory statements, I believe, right? Where he's claiming she's defaming him. Wallace denies making any... The court should dismiss. Texas or New York should apply to all Lively's claims. New York choice of law points to Texas or New York because the rule against intentional infliction of emotional distress is conduct regulating in plaintiff claims the alleged acts occurred. Lively's California cases, so they get into, again, it's all of the talk about where these, trials are going to happen. I don't think this is too important for us right now. Let's go to the conclusion. Beyond being listed as parties, the Wallace parties are barely mentioned in Lively's 141-page, 482-paragraph, 5 attached exhibits amended complaint. If this were a Hollywood movie, the critics would deem the script overwritten and the peripheral characters, Wallace and Street, underdeveloped and therefore cut from the film. Of course, no one likes to be described as a bit player or an afterthought, but the Wallace parties will get over it because this lack of attention necessarily leads to the conclusion that there is no adequate factual predicate for this court's exercise of jurisdiction or venue in the case. As to them, should be dismissed without prejudice. In the alternative, the claims against them should be severed and transferred to the United States District Court for the Western District of Texas, Austin Division, where a claim against Lively by the Wallace parties is pending. But if we are truly into almost happy endings, the court could reach the merits, and if it does, dismiss the claim against the Wallace parties with prejudice. We predict the Wallace parties and the critics would like that. A cleaner storyline and, sadly, for some, less attorneys' fees. Wow, what a nice conclusion. They were able to tie in Hollywood. Hey, my client's a bit character. You need to cut him out of the script. The critics will enjoy if I love it. Real visual, good stuff. And in the end, Jed Wallace, one of the only people, I think the only one right now, who's got a sworn affidavit saying, I got nothing to do with this. You'll find nothing. And of course, small business, probably a one-man shop there in Texas, right? Doesn't want to be sunk in legal fees. I think Lively's latest document at him was 800 pages. So God knows this is already probably costing him in the six figures. Either way, Chef's Kiss, as an audience member, I enjoyed the visuals there at the end. Fascinating stuff. I didn't know what we were going to get to. Sometimes I like to read it and feel live with you guys. And, some of these things are nothing burgers, but I think it was juicy. This burger had a lot of juice in it, right? It was a juicy burger. Juicy burger on a Thursday. All right, this afternoon, we're going to talk about a PR war happening, and a article may have been seeded by Blake Lively's side that may be floating her preparing to settle. Let's settle this one. Will that happen? We'll have to see. That's coming next, the afternoon rush. If you didn't catch the morning rush, go check it out. We got all things politics, tariffs, stock market, the whole 9 yards. And anyhow, catch up on that. We'll be back in a little bit. I'm Dave. This is The Rush.